Okay, we will start the second session for today. The lecture given by Professor MBENGUE under the theme of the reform of the investment regime and investor-state dispute settlement. Professor MBENGUE is Professor of International Law at University of Geneva and Sciences Po Paris School of Law, and he has he specializes in international investment law for last 15 years, and another special expertise also includes sustainable development law, law of the sea, and international dispute settlements. And it is a great pleasure to welcome Professor MBENGUE to this session. So the professor, the floor is yours.
Thank you so much, Director Yukito. Excellencies, distinguished participants, dear colleagues and friends, good morning to everyone. It's really a great pleasure, privilege, and honor for me to be here, and even more to have the opportunity to see some familiar faces that I've been meeting throughout the years in the world of international law. So I would like to thank warmly the Ministry of Foreign Affairs of Japan for giving me this honor and opportunity to exchange with all of you on one of the, I would say, hot topics of today's international legal system, the issue of the reform of what we call the investment regime, or the reform of international investment law, together with the reform of ISDS, of investor-state dispute settlement. And I have to say, looking at the syllabus, at the schedule of the course, I have to say that there's a link between this course and the course before, because in the course before you were talking about business and human rights, so basically how to make sure that business is more compatible, more respectful of human rights. And one issue in the reform of the investment regime, it's how to make foreign investors or foreign investments or business, how to make them more responsible, so meaning how to make them also more respectful of human rights. So there is a continuity, a continuum between the two topics. So what I would like to do with you today is to cover the points that you see here on the outline. So briefly, I will come back on the roots of the investment regime. Where is it coming from? And how at some point the investment regime was mostly a bilateral type of regime. But despite this bilateral character, what we see today is an expansion of the investment regime, and we will look at what are the common features of what we call international investment agreements, and then discuss why there is a need for reform, and then from there we will look at the challenges of future investment negotiations, and we will conclude with some few takeaways. So let me start with the roots of the investment regime. I don't know if I can provoke the participants here in the room and ask whether someone has an idea of, of the year that is usually considered as the birth year of international investment law. Or maybe to make it simple, we can play with centuries. Do you think that international investment law can be traced back to the 21st century, the 20th century, the 19th, the 18th, earlier on? No? So, international investment law, there's a consensus to say that international investment law was born in the 18th century. So, and to be more precise, in 1778, when the United States of America and France concluded the first treaty of amity and commerce ever, there is a strong consensus to say that this is the birth point of international investment law. Of course, at that time, the notion, the term investment was not yet a term of international economics. The term investment started to be used mostly in the second half of the 20th century. So no one at that time was using as such the term investment. But the reason why there is a strong consensus to say that this is the birth of international investment law is because in that treaty of amity and commerce between France and the US, both countries incorporated provisions through which they took the commitment that they would protect foreign assets on their territory. So the French government took the commitment that it would protect US property, US assets on its territory, and the US government took a reciprocal commitment that it would protect French property and French assets on its territory. And as many of you know, the whole raison d'etre, the whole objective of international investment law is the protection of foreign assets, of foreign property that is based on the territory of another state. So because of those provisions, this is the reason why you have a consensus to say that this is the beginning of international investment law. The question you need to ask yourself is why? Why in 1778, both the US and the French government decided to incorporate such treaty provisions in their treaty of amity and commerce? And the reason, I put a question mark, the reason was customary international law. I put a question mark because, of course, there are disagreements on whether there was already customary international law at that level. But from the standpoint, from the perspectives of France and the US, you know, at that time, they considered that customary international law was already requiring states to protect foreign assets and foreign property based on their territory. So it was on the basis of customary international law that they decided to incorporate such provision because both countries were convinced that the customary international law at that time, so the general, constant, and consistent state practice of that time was already requiring states to give protection under international law to property, to foreign property and foreign assets based on their territory. So this is the reason why they incorporated those provisions. But you see that I was very cautious and I put a question mark after customary international law. Why did I put a question mark? Because, of course, the position of France and the US was very, very quickly, you know, rejected by some countries and some lawyers, in particular from the developing world, from countries that were not yet advanced economies. And one of the strongest rejection of the French and US doctrine, according to which foreign property, foreign assets should be granted protection under international law on the territory of a state, the biggest rejection came from Latin America back in the days. So in the mid 19th century, so about 60 years after the conclusion of the Treaty of Amity and Commerce between the US and France, in the mid 19th century, around 1850, there was a very famous Argentinian lawyer. I think that many international lawyers here in the room know that name. Argentinian lawyer who was called Carlos Calvo. Carlos Calvo, very famous lawyer who, back in the days, wrote a book in which he rejected the idea that international law would protect or would be applicable to the protection and the treatment of foreign property and foreign assets on the territory of a state. So basically, the old Calvo doctrine was a rejection of the very idea of even international investment law, the very idea that the investment regime should be internationalized. The old Calvo doctrine consisted in saying that, no, you know, foreign investors or foreign investments, when they come to the territory of a state, they should be subject to the same laws, to the same domestic laws and regulations than the domestic investors. So Calvo rejected that international law would give special protection to foreign investors or foreign investment. The old doctrine was to say, no, you know, the foreigners, if they come on the territory of a state, they should be subject to the same rules than the domestic investors. If the rules are favorable, life is good. If the rules are not favorable, then life is bad. Oh, but that was the old Calvo doctrine. And the Calvo doctrine was not just a substantive rejection of the idea of international investment law, so substantive rules. it was also a procedural rejection. The Calvo doctrine also rejected the idea that foreign investors should have access to international arbitration in case of dispute with, host states. So in case of dispute with states in which their property would be based, Calvo rejected the idea of, internationalized dispute settlement mechanism to solve investment disputes. So not only he said that foreign investors should be subject to domestic laws, but in case of dispute, the dispute would have to be settled by domestic courts and not by international courts and tribunals or international arbitration. So you see that at the beginning there was some battle. There was some battle regarding the very idea of international investment law, the very idea that international law should govern or should be applicable to the treatment and the protection of foreign assets and property. And this battle was there for till almost 1945. Also, from the inception of international investment law till the end of the first half of the 20th century, there was this struggle between very advanced economies and less advanced economies that we call today developed states, battle between developed states and developing countries. Starting from the second half of the 20th century, so after 1945, after the end of the Second World War, the idea of international investment law was accepted. Also, there was no longer battles about whether international law can be applicable to the protection of foreign assets and foreign property. So there was a shift. There was a shift in the battle. The shift, the battle after 1945 focused on whether the investment regime should be multilateralized or not. Also, before 1945, battle on whether international law should be applicable, whether there should be something called international investment law. After 1945, more and more states admitted that international law could be applicable, but the question was, should it be or not through multilateral rules? So rules that would be applicable within the international community as a whole. And the very first attempt to multilateralize, I don't know if someone has actually an idea of when was the very first attempt to multilateralize the investment regime after 1945. Very good. The very first attempt was the Havana Charter. The Havana Charter on the International Trade Organization, which was supposed to incorporate the GATT. In 1948, there was this treaty concluded within the UN called the Havana Charter, very famous, that was supposed to establish the International Trade Organization, which would have been the predecessor of the World Trade Organization. And in the Havana Charter, there were actually provisions on the treatment and the protection of foreign investment. Because back in the days, investment and trade was seen as the two sides of the same coin. It's later on that there was separation between the trade regime and the investment regime. But back in the days, investment and trade was seen as the same side of, as the two sides of the same coin. And this is the reason why the Havana Charter actually incorporated rules on how to protect, how to treat foreign investment. But as we know, many of us here, the Havana Charter never entered into force. It never entered into force because of US refusal to ratify it. And this is why that first attempt to multilateralize the investment regime failed. So when that first attempt among others failed, what we witnessed by the end of the 1950s, so 10 years after the conclusion of the Havana Charter, what we witnessed was first a bilateralization of the investment regime. When the first attempts to multilateralize failed, we witnessed what I call the bilateralization of the investment regime. So it's basically states using the bilateral way or the bilateral pass, using the bilateral pass or the bilateral way to protect or to regulate foreign investment. And the first bilateral investment treaty, someone remembers here when the first, yes, please, sir. Very good. I guess you are from Pakistan. Very good. The very first bilateral investment treaty ever concluded was the famous Germany-Pakistan BIT of 1959. Germany went into the bilateral pass because Germany realized that it would be very hard. It would be very hard to actually come up with multilateral rules when it comes to the protection and treatment of foreign investment. And this is Germany and Pakistan that actually launched that new trend back in the days of the bilateralization of the investment regime. So 1955, conclusion of the first BIT ever. As you can see, I'm talking about bilateralization because a BIT, as the name indicates, is a treaty between only two countries. Between only two countries. That's why it's called BIT. BIT or BIT, depending on how you want to call it. But that's why it's called bilateral investment treaty, because it would be a country concluded only between two countries. So applicable in the investment relationship between two countries. And traditionally those BITs were treaties concluded between a capital exporting country and a capital importing country. That was the traditional physiognomy of bilateral investment treaties when Germany and Pakistan launched it. The idea is that you would have a developed country, what we call a capital exporting country, concluding a BIT with a capital importing country, so a country that would want to attract foreign investment or foreign direct investment on its territory. I'm saying that was the traditional physiognomy because, of course, things evolved. If you look today at the physiognomy or at the architecture of bilateral investment treaties, today we have more and more what we call South-South bilateral investment treaties. So bilateral investment treaties concluded between developing countries. You have a lot of bilateral investment treaties, for instance, between China and African countries, or China and other Asian countries, and China and Latin American countries. You have a lot of bilateral investment treaties between countries from the Middle East, Gulf countries, with African countries or Latin American countries, Asian countries. So the physiognomy of bilateral investment treaties has evolved. It's no longer just a north-south perspective. It is also now more and more south-south. But the idea is still the same, is that it is usually a treaty concluded between a capital exporting country and a capital importing country. So this is how this trend started of bilateralization of the investment regime. Bilateral treaties, that's how they became the major pillar of the investment regime. They became the major pillar of the investment regime. And again, as I said, because there was resistance to the multilateralization of the investment regime. And this is a difference for those of you who are interested in trade and investment. This is actually a big difference between trade and investment. You know, for the trade regime, for the multilateral trading system, since 1945, there were a lot of efforts to multilateralize it. Also, GATT, as the legal counsel, the honorable legal counsel from the African Union was saying, the GATT was the idea of, let's have a multilateral club, let's have multilateral rules regarding trade. So for the trade regime, it was going multilateral. The investment regime deviated and went into something more bilateral because of the resistance. And you know, the resistance came from two aspects. The first aspect, why there was resistance by the end of the 50s, early 60s, as you may surely remember, you remember that in the early 60s, many developing countries in Asia, Africa, Latin America, launched the battle of what we call the new international economic order. Also, many countries that used to be colonized, you know, when they became sovereign nations, They went to the UN General Assembly, where they had majority, where they still have majority, and launched the battle for the new international economic order. And the battle for the new international economic order was a battle against the international economic order of that time, because many developing countries considered that the international economic order of that time was, neo-imperialistic and of colonial inspiration. So they went to the UN and contested the international economic order of that time. And one aspect of the battle against the international economic order, or one aspect of the battle for the new international economic order, was actually to contest the investment regime that rich countries were trying to push forward at that time. Because many rich countries at that time at the level of OECD, the OECD, the Organization of Economic Cooperation and Development, many rich countries at that time within OECD were trying to push for a multilateral treaty on the protection of foreign private property. And developing countries launched the battle of the new international economic order to actually reject those attempts, to impose multilateral rules, in particular multilateral investment rules, to developing countries. So this is sometimes one aspect that is forgotten of the battle for the new international economic order. But the battle for the new international economic order had an investment dimension, an investment law dimension that was that developing countries did not want to accept the investment standards that rich countries were pushing for. One concrete example I can give you is the example of the Hull formula. Does someone here remember the Hull formula? In international investment law, there is a formula that is very famous that we call the Hull formula. Hull, H-U-L-L. Hull was the name of a secretary of the state of the US in the 1930s who went into a diplomatic battle with his Mexican counterpart, because in the 1930s in Mexico there was an agrarian reform, and the agrarian reform led to the expropriation of many US farmers. Also expropriation meaning the state taking the property of many US farmers. And when this happened, it created a diplomatic battle between the US and Mexico. And Hull, who was the Secretary of State at that time in the US, wrote to his Mexican counterpart and said to him, under customary international law, so they repeated customary law, under customary international law, if you expropriate foreign investments, you need to pay prompt, adequate, and effective compensation. Prompt, adequate, and effective compensation. Many of you, if you read the treaties of your countries, the BITs of your countries, you will find that formula. We call it the Hull formula. That expropriation should lead to prompt, adequate, and effective compensation. But in the early 60s, when developing countries went for the battle for the new international economic order, the first episode was the adoption of Resolution 1803, very famous resolution, the resolution on permanent sovereignty over natural resources of 1962. That was the first episode of the battle when the General Assembly adopted Resolution 1803 entitled Permanent Sovereignty over Natural Resources. Read paragraph 5 of that resolution. You will see that developing countries say, okay, in case of expropriation, they should pay appropriate compensation. So they rejected the Hull formula. They said, we are happy to pay compensation, but it's not prompt, adequate, effective. It's appropriate compensation. So this is why you had, this resistance because of this battle for the new international economic order. Many developing countries trying to resist standards that would come from developed worlds. But there was another aspect of the resistance in the early 60s that explained why they went for bilateral and not multilateral. Is that at that time, many countries were convinced that when it comes to substantive rules, so substantive rules means how to protect, how to treat foreign investments. Many developing countries at that time considered that substantive rules should be subject to domestic jurisdiction, or should be subject to domestic laws and regulation, that there was no way that the protection or treatment of foreign investment should be the same across the world. So there was a rejection of, let's multilateralize the substance. Let's multilateralize rules for protection and treatment of foreign investment. The only compromise that most developing countries were ready to make was only on procedural rules. They were ready for multilateralization of procedure, not of substance. They were ready to agree to some procedures for the settlement of investment disputes that would be common to everyone, but not the substance. And they were ready for multilateral rules. One very good example that many of you know is which, for the procedural rules, in the 60s, an example of the multilateralization of the procedural rules. So of a procedure for the settlement of investment disputes. Very known. I'm sure if I said, you would say, of course. In the 60s. The ICSID Convention. The famous ICSID Convention. The Washington Convention of 1965, ICSID, which is today the most known institution for the settlement of investment disputes. ICSID, ICSID, the International Center for the Settlement of Investment Disputes, was actually established by the Washington Treaty of 65. Yes, sir, please. Thank you very much. The New York Convention a bit earlier on, 1958, excellent. I gave the example of ICSID, but thank you so much. Earlier on, you had the New York Convention on the recognition and enforcement of foreign arbitral awards. So developing countries were ready for multilateralizing procedures, but not substance. And this is why it went through the bilateral back door, okay? But, and this allows me to go now to the third part of the session, the bilateral character of the investment regime, of course, evolved. It evolves. Today, when you look at the investment regime, at what we call the investment regime or international investment law, what you can see is a sophistication of the investment regime. Also, the investment regime that did not get frozen to bilateral investment treaties, today you have what we call an expansion of the investment regime. So the investment regime, for instance, in particular in the developing world, is very much based also, so in addition to BITs, based on national investment laws. Many of the countries here in the room, many of our countries here in the room, if you go and check, you know, your legal system, you will see that you have a specific national investment law that is applicable. In Africa, they like to call them national investment codes. National investment codes. So many developing countries, in addition to the BITs they conclude, have also national investment laws applicable. And those national investment laws, they are not your usual type of domestic laws. Because, you know, usually under international law, domestic laws are facts. No, domestic law is not a source of international law. If you take the case law, repetitive case law of the International Court of Justice and before of the Permanent Court of International Justice, municipal laws are considered just as facts in the international legal system. National investment laws, they are not facts. They are a source of international law. They are a source in the investment regime. Why? Because these national investment laws, they contain what we call elements of extraneity. They contain extraneous elements. When a state adopts a national investment law, a state is taking commitments towards, most of the time, foreign investors. And because of that extraneous element of the state taking international commitments, this is a source of international law. This is a source of international investment law. This is what we call, in the traditional doctrine of the sources of international law, this is what we call a unilateral act of a state. A unilateral act of a state. You know that under international law, a state can bind itself A state can come, Japan can come and say, I take the commitment no longer to do this to the international community. It creates what we call binding unilateral commitments for Japan. So in these national investment laws, states, they commit themselves. For instance, you have national investment laws where states say, well, if you are a foreign investor, if you come and invest in my country, if you have a problem, you can bring me to international arbitration. That's an international commitment. So you see, this is not your typical domestic laws. This is a source of international investment law. Another very important source that shows the expansion of the investment regime, again, in particular in developing countries, investment contracts. You know, since the 1970s, 1980s, we've been witnessing not only exponential adoption of national investment laws, but also exponential conclusion of investment contracts. So in addition of BITs, states would also conclude investment contracts. What is an investment contract? An investment contract, it's an agreement between a private foreign investor or private foreign investment and a host state. Also, that's the difference between an investment contract and a BIT. A BIT is concluded between two sovereign states. That's how you would call it BIT. Investment contract is concluded between a state, a host state, and a foreign, private foreign investor or private foreign investment that would come to the country. So this is another source, another important pillar of the investment regime, investment contracts, because again, in investment contracts, a state would, most of the time, take international commitments. A state would tell an investor, if we have a dispute, we can go to ICSID, we can go to international arbitration. A state would take certain international commitments like what we call stabilization clauses. Stabilization clauses, you find them a lot in investment contract where a state would tell a foreign investor in a contract, you know, if I change my law and my law is less favorable, it won't apply to you. It won't apply to you. That's what we call stabilization clauses in investment contracts. So that's another important source that shows the expansion of the investment regime. And then, last but not least, third aspect of the expansion, the multiplication of what we call international investment agreements, IIAs. Whenever you see the acronym IIAs, it means international investment agreements. So actually, this is the language used by UNCTAD. UNCTAD, the United Nations Conference on Trade and Development, which is very much involved in investment. UNCTAD calls all this constellation of investment treaties or investment agreements, they call them IIAs. Okay? And so what we've been witnessing in particular since the early 1990s is, you know, multiplication of IIAs. Between 1959, Germany, Pakistan, BIT, and the end of the 1980s, IIAs were mostly BITs. You had some exception, of course, in the Arab world. You had some exception with the 1982 Arab Investment Treaty. There was another exception with the investment treaty of the Organization of Islamic Conference in the 1980s. But most of them were BITs. Starting from the early 90s, we witnessed the multiplication of IIAs. So IIAs would not just be BITs. They wouldn't just be BITs. Let me explain it a bit more in detail. So what do I call by multiplication of international investment agreements? Well, first aspect of the multiplication, exponential conclusion of BITs. Starting from the 1990s, we witness a huge wave in the negotiations and conclusions of BITs. Till the end of the 1980s, you know, BITs were mostly concluded upon the initiative of some European countries. Some European countries, so Germany, Switzerland, Netherlands, France, Italy, they were mostly the ones who were pushing for the negotiation of BITs. Starting from the 1990s, we saw other capital exporting countries being more and more involved in the negotiations and conclusions of BITs. One example I wanted to give you. Sorry, I want to come back. Yeah, I see. Sorry, I wanted to give you the example of Japan, since we are in. If you look, for instance, at the relationship between Japan and BITs, I'm trying. Yeah. So this is the UNCTAD website. Oh no, it doesn't appear. Sorry. Sorry. So, thank you so much, Yukito. I saw that it would go directly on the internet. Okay, but it doesn't appear here, no? I have to come back to the. No, but I just wanted to show you this. So this is the UNCTAD page on what we call IA's navigator. So whenever you look for the treaties concluded by a country or your own country, you can find them there. And if you look at Japan, for instance, here, you see that Japan concluded, according to the UNCTAD website, Japan concluded its first BIT in 1977 with Egypt. That is when Japan concluded its first BIT. So almost end of 70s by comparison to other European countries. But then look the pace for Japan. You know, then after the one with Egypt, 5 years later there was the one with Sri Lanka. Then again 6 years later, the one with China. So meaning that between the end of the 70s and the end of the 80s, Japan concluded only 3 BITs. You see? But then once you start now looking from the 1990s, Japan, Turkey, 1992, 1997, 1998, 1998, 1998, 2001, 2002, you see that the rhythm started to be much more accelerated. And so this is an example of, you know, capital exporting countries that used not to negotiate BITs that started in the early 90s to negotiate more bilateral investment treaties. So Japan is an example. Another example is the US. The US started to negotiate BITs in the 1990s. Same for Canada. Same for Australia. So other capital exporting countries started to use the bilateral track in the early 1990s. And this is what explains the exponential, you know, development, exponential conclusion of BITs that actually justify why at some point there were more than 3,000 BITs concluded in the world. More than 3, yeah, there was a moment where there was at least 3,200 BITs that have been concluded in the world. So this is because of newcomers in the bilateral BIT constellation, and which explain why I'm talking about multiplication of IAs. But multiplication of IAs, if I can come back here, yeah. Yeah, okay. This I know how to do. Very good. So multiplication of IAs is not just limited to the exponential conclusion of BITs. There was another aspect that explained the multiplication of IAs is what I would call the spaghetti ball of investment chapters of free trade agreements or other economic partnership agreements. Starting from the early 1990s, yes, please, sir.
Sorry to interrupt. Can you use a microphone, because online participants are also listening.
Thank you.
I think
no, it's a pleasure.
Can you hear me now?
Yeah, yeah.
C'est bon? So wasn't one of the reasons for this exponential growth in the 1990s was the fall and the decline of the erstwhile Soviet Russia?
True.
And the rise of a unipolar world.
Excellent. No, thank you so much, dear colleague, yeah, that is another explanation, of course, what I would call a geopolitical, explanation. It's true that starting from the 1990s, not that BITs were just, a tool for other capital exporting countries, but you are right to say that, the fall of the Berlin Wall, the end of the Cold War, made countries like Russia, Turkey, and former Soviet Union countries also using now the bilateral investment tract, the treaty tract. That's excellent. I totally agree with your point. But another element of the multiplication is what I call the spaghetti ball. I'm using the word spaghetti ball because there was a director general of the World Trade Organization back in the days, Pascal Lamy, who actually called all those free trade agreements a spaghetti ball because there was an exponential increase in the conclusion of free trade agreements, and so he called them the spaghetti ball. But these free trade agreements, most of them came up with what we call an investment chapter. So they are called free trade agreements. So they deal mostly with how to liberalize trade in a given area. But they came up, most of these free trade agreements, with specific investment chapters. So those investment chapters, one of the most famous was the NAFTA Chapter 11. NAFTA, the North American Free Trade Agreement between Mexico, US, and Canada. NAFTA had that specific chapter called Chapter 11 that was dealing with investment. So when you look at those investment chapters of free trade agreements, they look like BITs, they taste like BITs, they smell like BITs, but they are not BITs because, first of all, FTAs are not necessarily concluded between only two countries, first, so you cannot call them BITs. But an FTA is not an investment treaty. An FTA is mostly about free trade. And that's why even if those chapters look like BITs in terms of content, you can't call them BITs, you have to call them, investment chapter of an FTA or of an EPA, an economic partnership agreement. This contributed to the multiplication of international investment agreements, and so to the expansion of the investment regime. And what I wanted to show you again, if we can come back to the page on internet, and it's that last time I disturbed you with that, yeah, the page, the internet page earlier on, because I wanted to show again. Yeah, and that's the last time I'm disturbing you in principle with this. Again, if you take the page on Japan, so you see you have on the UNCTAD page, you have Japan BITs, and then you have what UNCTAD calls treaties with investment provisions. So they are not BITs. There are other treaties like FTAs or economic partnership agreements, but that contain specific investment chapters or provisions. And you see that there's a lot. And many of the countries here, you are in the room. If you take, for instance, the Indo-Pacific Economic Framework Clean Economy Agreement, it has specific investment provisions. And you have Japan there, but then you have Brunei, Darussalam, and other countries here, which I think are in the room. One that is very famous in the Asian region, RCEP. RCEP, the Regional Comprehensive Economic Partnership of 2020, where you have ASEAN countries, Southeast Asian nation with Japan, Australia, China, Korea, New Zealand, etc., with specific investment chapter. So this is a I would say new trends in the making of international investment law. New trends in the making of international investment agreements. So having specific chapters or provision on investment in free trade agreements or economic partnership agreements. And in Africa, it's also very known because in Africa, for those of you who come from different parts of Africa, you know that in Africa we have different regional economic integration organizations. And in those regional economic organizations, regional economic integration organizations, you would find in the treaty creating those regions, you would find specific provision or specific chapters on investment. So ECOWAS, Economic Community of West African States, SADC, Southern African Development Community, COMESA, Common Market of Southern and Eastern Africa, you would find this type of approach. So this is the other reason why we witness the multiplication of IAs, and then I come back to the PowerPoint, and then yeah. Okay, thank you. Sorry. Thank you so much, sir. Then a third explanation for the multiplication of IAs is the increase of regional and continental investment agreements. So besides investment chapters in FTAs, you have today a new generation of specific investment treaties, regional investment treaties. So an investment treaty that is regional and dealing only with investment. So it's not a free trade, because again, a free trade agreement is regional, but it deals with trade with a specific investment chapter. A regional investment treaty is a treaty adopted at the level of a region dealing only with investment. One very known example is the 2009 ASEAN investment agreement, where you have an investment agreement applicable in the ASEAN region. But as I told you, that trend was actually the first region that launched that trend was the Arab region. Because in the 80s, in the Arab region, in the context of the League of Arab States, they had already an investment treaty on Arab capital, and then Organization of Islamic Conference. They were the ones who launched it in the 80s, but then these were isolated, isolated initiatives, examples. But in the last, I would say, 15 years or so, we've been witnessing now an exponential development of this, how do you call that, of these regional investment treaty. I gave you the example of the ASEAN one, but right now, for instance, in Africa, last year we finalized the negotiation of a continental investment treaty. So an investment treaty that is supposed to apply at the entire level of Africa. So that is an African exception. It's called the Investment Protocol to the African Continental Free Trade Area, AFCFTA. AFCFTA, African Continental Free Trade Agreement, where now the idea is to have a continental regulatory framework on investment in Africa. This is like unprecedented in the history of the investment regime. And then, last but not least, fourth element that explains the multiplication of IAs, the development of what we call sectorial investment agreements. Sectorial investment agreements. So an investment agreement that is dealing with one sector of investment, which is dealing with one sector or one very specific type of investment. And the most famous is the Energy Charter Treaty. I think Energy Charter Treaty was 1993 or 1994. I'm always confusing, but the famous Energy Charter Treaty that was concluded, back in the days, it was a treaty concluded mostly between, Western European countries plus Central and Eastern European countries, but a country like Japan is also part of the Energy Charter Treaty, but it was mostly Western European, Central European, Eastern European countries plus Russia that concluded this investment treaty that would regulate investment in the field of energy. Today you have a lot of those developed countries, in particular in Europe, that are withdrawing from the Energy Charter Treaty because they had a lot of arbitration against them based on the Energy Charter Treaty, and they're not happy with that, and they're withdrawing. And the Secretariat of the Energy Charter Treaty, for the little story, is now reforming the Energy Charter Treaty to make it more climate change friendly, climate change compatible. And guess what? Now the Energy Charter Treaty is going in many developing countries and trying to convince them to get into the Energy Charter Treaty. So in Asia, in Latin America, in Africa, they're trying to convince many of our countries to now become parties to the Energy Charter Treaty. And of course, I don't want to take any personal position on that there, but think twice, because you have the usual countries that were there are now saying, let me get out. And then, you need to ask yourself why they're getting out of that treaty if it was that great. That's just for the little information. But you see, this is what we can call the expansion of the investment regime. And in particular, one of the most important aspects is really this multiplication of IIAs. So it's wrong today to think that the investment regime is only about BITs. It's wrong to think that it's only about BITs. It's wrong to think that the reform of the investment regime should be limited to BITs. Because in reality, from a treaty perspective, it's not just about BITs anymore. It's a broader, bigger constellation of IIAs. And this brings me to part 4, the common features. The common features of all these IIAs. Because yes, there has been multiplication, but they have common features, all those IIAs. I would say at least the dominant model, or the dominant model of the IIAs. So the IIAs that have been concluded between 1959, first BIT, till I would say the early 2010. Till the early 2010, because the whole idea of the reform started after 2010. So all those IIAs of what we call the first, second, and third generation, so between 1959 and 2010, they have common features. First common feature, focus on investment protection. That's the first common feature. Focus on investment protection. If you look at the broad majority of the dominant model, I speak under the control of those of you who know those treaties and who have been negotiating them, they mostly focus on investment protection. So how to protect foreign direct investment or foreign property or foreign assets. Dimension is mostly about protection. Okay? That's one common feature. And that you need to keep in mind to understand why or where the reform is going. Second common feature, broad standards of investment protection and treatment. How many of you here in the room, or online, but online I wouldn't see, but how many of you here in the room have read BIT from the beginning till the end? Two persons only. 3, 4 persons in the room. 4, 5 persons, 6. Yeah. So that like minority of the colleagues here in the room have read a BIT from A to Z. Well, if one day you go and you read, BITs concluded by your countries, what I call the dominant model. So you take a BIT from the 60s or 70s, 80s, 90s. You will see that BITs are the most minimalistic treaties on the planet. 3 pages. I mean, dominant model, because it's changing now. It's changing. I'll come to that. But the dominant model that our countries have been negotiating, if you look at them, 3, 4 pages maximum. Because they would contain just very broad standards. The 2 states, the contracting parties, shall grant national treatment, period. Shall grant most favored nation treatment, period. Shall grant fair and equitable treatment, period. In case of a dispute, investor can bring arbitration here or there. That's it. Sometimes I've been teasing sometimes my students in Geneva or in Paris. I've been telling them, honestly, guys, in international investment law is not hard to know. It's about 5, 6 standards, maximum. For those of us who do, I don't know, law of the sea or I don't know, humanitarian law, 6 standards. This is what international investment law is about. Because most of these treaties were very limited to just broad standards of investment protection. What makes international investment law complicated is the case law. It's the case law because then you have hundreds and hundreds of hours going in different directions. That's what makes it hard. But the treaties, the BITs in particular, that as such the dominant model, they were really minimalistic. In a week, you can learn the standards of international investment law, which we cannot do with law of the sea or law of treaties, etc., or international environmental law, etc. So very broad standards. This is what was the common feature of these BITs, but also IAs. Keep it in mind because it will allow you after to understand where the reform is going. Then last but not least, the ISDS. ISDS, Investor-State Dispute Settlement, which is the elephant in the room. The ISDS. The dominant model of IAs would contain this very broad offer to arbitrate. You know, some scholars or even practitioners, I speak under your control, my dear friend, some practitioners would even call it blind offers. Blind offers to arbitrate. Oh, blind offer, meaning that 2 countries would conclude a BIT and they would blindly just say, well, in case an investor has a dispute with me, the investor can bring me to arbitration. So you don't even know to whom you are offering the arbitration. That's why some practitioners would call it a blind offer to arbitrate. So it's not just broad, it's blind. Because then you don't know, you don't know who's going to use it one day. You don't know who's going to use it, you know. If you take certain treaties like the Dutch, like treaties concluded by Netherlands, you know how you can become an investor in a foreign investor, how you can become a Dutch investor according to Dutch treaties? You go tomorrow to Amsterdam, you open a mailbox, you pay a fee, you have a Dutch company. Are you following me? So what does it mean? It means that if one day I go to a country, I invest in a country, I have a problem with that country, I want to bring that country to arbitration, what do? I go to Amsterdam. I turn myself into a Dutch company, I come back, I bring arbitration against that country that has concluded a BIT with the Netherlands because it's so easy to be a Dutch investor and the Dutch BITs. So that's why I'm saying it's a blind offer. You don't know who's going to use it against you. Sir, you want to intervene, please? No? But you see what I mean? You don't know who's going to use it against you. So dominant model of IAs went in that direction. This is one of the common features. Broad offer to arbitrate. Whenever the investor has a problem, the investor can automatically, because you don't need consent. You don't need consent. The consent was given in advance in the treaty that if an investor of this nationality with which your country has a BIT has a problem with you, that investor can automatically trigger international arbitration against you. That's why we call it broad offer to arbitrate. And you see why it's called ISDS. You see why it's called ISDS, investor-state arbitration. Because who can trigger? Who can trigger, the state or the investor? The investor, thank you. It's the investor that can trigger. It's not the state. This is something very unique in the constellation of international dispute settlement. Because normally the use of international dispute settlement clauses is reciprocal. You know, if Pakistan conclude a treaty, usual normal treaty with I don't know, Japan or Senegal, my country, if there is a dispute settlement clause, you can use it, I can use it. It's reciprocal. Here, it's not reciprocal. The triggering is unilateral, is given only to the investor to trigger arbitration against the state. meaning that the state would most of the time not have the possibility to complain of violations of human rights or whatever by the foreign investor. Because it's investor state and not state investor. It's investor state dispute settlement, okay? But these are the three, I would say, main common features of the IAs. And this brings me to why. Because now I showed you what is the dominant, the features of the dominant model. And this brings me now to why. Why is there a need to reform all that? Why at some point, majority of countries, when I say majority, it's like broad majority of the countries on the planet, even universal, decided that there was a need to reform. You know, I'm insisting on this because sometimes people say that this is a developing country agenda. That's not a developing country agenda. The call to reform IAs is today a universal call. The first countries that were talking about the need to reform were, of course, developing countries because we were the first ones experiencing ISDS. You know, we were the first one being condemned by arbitral tribunals. So we were the first one ringing the bell. But today, there is a universal consensus that there's a need. Maybe there is no universal consensus on how precisely to reform sometimes, but there's a universal consensus on the need to reform. Why? Why? There is a consensus first on this. A consensus on the asymmetry of IAs. There is a consensus to say that IAs, dominant model of IAs or BITs, are asymmetrical. So imbalance. Imbalance. Why? You know, I told you, remember what I told you earlier on when we looked at the common features? I told you that majority of IAs focus on what? They focus on what? On protection, no? Very good. On investment protection. On investment protection. So what does it mean? It means that when you look at the traditional dominant model of IAs, what you will see is that it only contains rights for investors. Only rights, no obligations. Obligations are only on the states, the state parties. On the state parties. Otherwise, it's only about rights, you know. Sometimes I like to provoke and say that in every family, there's a spoiled child. Even if the parents don't want to admit, there's always a spoiled child. The spoiled child of the international law family is the foreign investor. Yeah, because these IAs, they only contain rights for foreign investors. No obligation. That's why it makes it complicated, for instance, to subject them to human rights obligations. The discussion you had before. Yes, because the treaty say, no, it's only right for you. Life is great. It's only right. Right to non-discrimination, right to fair and equitable treatment, right to compensation, right to arbitration, rights. No obligations. That is problematic. For any of us who know the traditional design or architecture of an international treaty, it's strange, no? Usually, treaties are a balance of rights and obligations. But you cannot just have obligations on one side and rights on another side and no reciprocity. So that's the first problem that, you know, explains why there's a need to reform. Second one, the regulatory shield. Has anybody here heard about the regulatory shield? What do we mean by IAs being a tool or a source of regulatory chill? Because that's one of the big criticisms there on the table. Yes, please, sir. Yeah. You have the microphone? Thank you.
It curtails the freedom of states to make laws to regulate investors.
Thank you. Thank you so much. Regulatory chill means that IAs have been used to actually prevent states from regulating, from exercising their right to regulate. And this is serious, you know, there are many examples, and not only in the developing world, not only because that is Again, we think that it's only in developing countries, but even in rich countries, there are examples in which a state wanted to adopt, I don't know, a new climate change policy, and the investors, threatened the states that they would use the IAs, they would use investor-state arbitration if they move ahead. And the states backed down. Yes, backed down, meaning decided not to go ahead with a new regulation to fight emissions of greenhouse gases on their territory. You have examples of countries that wanted to adopt new tobacco legislation that would be more protective of public health, and they backed down. They backed down because the foreign investor, I'm not going to give the name, said, if you move ahead, I'll bring you to international arbitration. And I'll ask compensation for billions and billions of US dollars. This is called the regulatory chill. IAs being used to prevent states from regulating in the name of the welfare of their people. This has been evidenced. There is plenty of evidence. Read, if you want, for instance, very recent report of the UN is the report of David Boyd. David Boyd, the UN Special Rapporteur on, on the right to a healthy environment. David Boyd is the UN Special Rapporteur on the right to a healthy environment. He published a report last year entitled Paying the Polluters. Not polluter pays, paying, but paying the polluters, and how the ISDS regime is a hurdle, for governmental policies on climate change and the environment. Big report. It's a UN one. You can go check it out. It's online. So there is evidence of the regulatory chill created by the dominant model of IAs. Third problem, the tribunals. Yeah, because remember, and I know you, because you have a very recent example in Pakistan of that. But remember what I told you? That the dominant model, they contain what? Broad provisions, no? Broad provisions. Broad provisions. Meaning that you leave it all. You leave it all to an investment tribunal, to an arbitral tribunal, to decide the fate, to decide the meaning, to decide the scope of those broad provisions. When you say, well, in a BIT, the contracting parties shall grant or shall accord FET, fair and equitable treatment. Period. What does it mean? If I had a microphone now, if I had time, and I was with each of you with my microphone, asking you what do you think is FET, we would have 100 definitions of what is FET in the room. Believe me. Yeah? You can put whatever you want there. And this is what happened, that investment tribunals, because of these broad provisions, went for very broad interpretations of those clauses. So for instance, some investment tribunals woke up one day and say, FET means the legitimate expectation of foreign investors. So when an investor goes to a country, he or she has legitimate expectations. If the legitimate expectations are disappointed, you'll pay compensation. That's why whenever you have arbitration against a state, you know what is the first claim of foreign investor in their notice of arbitration? Violation of FET. Violation of FET. Violation of FET, because you can put whatever you want in the basket. Violation of FET. That is a problem. Expensive interpretations. Another problem, before I get to the last one, inconsistent interpretation. This is once again connected to the broad provisions, because the provisions are so broad, not only they can lead to very expensive, meaning elastic interpretation, but they also lead to inconsistent interpretations. Because investment arbitration is based on ad hoc tribunals. So depending on who's sitting on a tribunal, you won't necessarily have the same interpretation of the scope or the meaning of a provision. It happens all the time. depending on who's sitting on a tribunal. So meaning there is no predictability, and no coherence in the investment regime. And without predictability or coherence, you cannot build strong, strong investment, you cannot have a sound, investment framework in your country. And this is one as a problem that justifies the need for reform. And then the last one, lack of integration of sustainable development goals. Yeah. Remember, I told you it's just focusing on investment protection, dominant model. So no reference to human rights, no reference to health, no reference to, to the environment, only economic protection of the investor. Yes, sir.
Est-ce que je peux rajouter un autre élément sur votre liste?
Oui, bien sûr. Merci.
I think one of the elements I would like to add to that list would be the quantum of damages, as to how they calculate damages.
Excellent.
Compensation. So just to explain it a bit, let's say an investor has invested $200 million today, and the project is going to have a lifespan of 20 years. And if that investor is going to be compensated for expropriation of his investment, he would be given 20 years profit in advance. That's how most tribunals calculate damages. And that's how, on an investment in Pakistan of about $150 million, I think, the investor got 4.5 billion US dollars. And I think with interest, it eventually became $5.5 billion.
Yes.
So for us, si je peux un peu modifier votre liste, j'aimerais bien rajouter quantum of damages tout en haut là.
I'll put it. Thank you. Thank you so much. I'll make sure that in the next version of the slide, I'll add that one, because but you are right. You are right to say that this deserves, a specific mention on why there is a need to reform, because at least from the perspective of developing countries, when you have a country that is already facing very, very constraining budgetary situation, and then you get condemned to pay 20 billion US dollars, to a foreign company because of how quantum is calculated, it is very problematic. For me, I was implicitly connecting it to the expensive interpretation, but I agree with you that it would deserve a specific one, so thank you, I'll put it next time. But it shows you that even compensation, yes, the treaty says compensation, but then the treaty is not clear on how do you do the compensation, the dominant IAs. And so this leaves room to arbitral tribunals to decide of the methodology of quantum and everything for damages resulting, for instance, from expropriation or the violation of other standards. Okay? But the last one I mentioned here is the lack of integration of sustainable development goals. We are living in an era of sustainable development. It's not me who says so. It's the international community. That's the consensus of the international community, that development has to be sustainable, meaning balance between economic development, social development, and environmental protection. These are the three pillars. That's the consensus of the international community. Of the 2030 agenda on development, it's sustainable development, integration of economic pillar, social pillar, and environmental protection. When you look at the dominant model of IAs, they only focus on economic protection of foreign investors. So the other dimension of sustainable development are not present. And this is problematic. This is problematic, particularly in an era where states have to regulate in order to achieve SDGs. It's problematic if you have treaties that say, yeah, but you don't have to care about SDGs. And if you care about them, you may have to pay compensation to a foreign investor. That's problematic. So that's why there is today, as I said, a rather strong universal consensus on the need to reform. So this brings us to almost the end the challenges. So how? So what does it mean? To reform means new challenges in future investment negotiations. Because reforming means that today, as an investment negotiator, you cannot do it the way you used to do it 20 years ago, 30 years ago, 40 years ago. There's a need to change the psychology of investment negotiations. And so I use the word challenges, but for me there is one challenge, the challenge, the biggest of all them. The biggest of all them in a context of reform, it's what I call balancing. That is the biggest, most important challenge today for all countries. All countries. Again, it's not a developing country agenda or developed country agenda. All countries are going in that direction. With diversity, but they're going in that direction. So the biggest challenge is balancing. How to balance IIAs. How to balance international investment agreements. What do I mean by balancing? First level of balancing the functions and objectives of IIAs. Balancing the functions and objectives of IIAs. I showed you that traditionally, in the traditional dominant model of IIAs, the objectives is very limited to investment protection. So balancing IIAs in a context of reform means we need to balance the functions and objectives of IIAs. First, fostering sustainable investment. Fostering sustainable investment. Making sure that IIAs are a tool for sustainable investment. So are a tool of investment of quality. Investment of quality. You know, the traditional dominant model of IIAs, they were mostly looking at quantity. How do we attract? You know, how do I attract a lot of FDI in my country, in Senegal? How? Quantity. Without caring whether that FDI is going to be good for your people. Because if you attract a lot of FDI at home, but the FDI at stake is polluting your water, is destroying your environment, is destroying the health of, then you don't gain anything. You don't gain anything as a country, in particular as a developing country. So what we need is to foster sustainable investment. IIAs can be a tool for sustainable investment, so investment of quality. So what does it mean? It means that today when states negotiate new generation of IIAs, they need to think about how to incorporate provisions that would foster sustainable investment. So for instance, making sure that the investment treaty doesn't lead to what we call the relaxation of health protection, doesn't lead to the relaxation of environmental protection, doesn't lead to the relaxation of social protection. One example I just wanted to give you that I find a very good example is of Japan. A very recent BIT concluded by Japan with Angola, with an African country. If I can, yeah, thank you, this one. If you look, this is the 2023 BIT between Japan and Angola, so very recent bilateral investment treaty. Look, one way to foster sustainable investment, look at the preamble, the last paragraph. It says, recognizing that these objectives, so the objective of protecting or liberalizing investment, can be achieved without relaxing health, safety, and environmental measures. That's an example. I'm not saying that that is the only way of doing it, but I'm giving you a concrete example of how now, for instance, Japan, when negotiating BITs with other countries, would not stop at just talking about protection, like back in the days, like many countries would do. But would say, okay, protection is there, but protection shouldn't be done at the detriment of health protection, environmental protection, social protection, etc. That is a way to foster sustainable investment. That is a way to use IIA as a tool to foster sustainable investment, okay? But to come back again here, So that is the first aspect of the balancing. First, making sure that an IA is used to foster sustainable investment. But then you have also the need to shift. You need to go beyond the investment protection. You know, today IIAs, they should be tool for investment promotion. They should be tool for investment facilitation. And they should be tools for investment cooperation. Very important. You know, the dominant model was just talking about protection. In the title, sometimes you would have the word promotion, but they were never promoting. In the title of many traditional BITs, you would find the word promotion, but promotion was never there. There was never any activities to promote, you know, FDIs on both sides. And then today there is a consensus to say that it's not just about protection or promotion, it's about investment facilitation. You know, if you want to attract investment, if you want to retain investment in your territory, if you want to expand investment in your territory, you need to go into investment facilitation. That's what investors, foreign investors, need beyond the protection. And so new generations of IAs, in terms of balancing objectives, do not just focus on protection. They now incorporate the promotion dimension, the facilitation dimension, and the cooperation dimension. Treaties, dear colleagues, treaties are a tool of what? Of cooperation. Treaties, they are here to facilitate cooperation. When you take the dominant model of IAs, they never really led to cooperation between nations. The day two countries would conclude a BIT, that's the day when they will forget about that BIT. Till the day you have arbitration, then you remember that you concluded a BIT one day with another country. No, really. There are some countries, for instance, in Africa, where when they got arbitration, they were not able to find the treaty, the BIT. And that's why UNCTAD put, no, really, that is real stories, what I'm telling you. That's why UNCTAD put all these treaties online. We were not able to find, because there was never any cooperation out of those BITs. Now, in a context of reform, investment cooperation is very important. Again, if you look, I don't have time to show you all that, but if you look at the new generation, if you look at the Japan-Angola BIT, you will see that it establishes joint committees, where the two states regularly would meet and discuss the issues regarding the BIT. How to promote, how to facilitate, how to make sure that investors from Japan would be responsible and investors of the other country would also be responsible, etc. Investment cooperation is important. That's why we conclude treaties, okay? Then last but not least, another important aspect of the balancing, preserving the right to regulate. You know, when I say that, I smile. I smile, I laugh at myself, because many of us here in the room, or maybe even all of us here in the room, we are international lawyers. We work for governments. You know what is state sovereignty? State sovereignty is the right to regulate on your territory. That's how a state is sovereign, is because a state can regulate on its territory. The only field I know in international law today where you go to negotiations and you negotiate a provision on the right to regulate are investment treaties. Yes. No, right to regulate is inherent. I speak under your control. Right to regulate is inherent to state sovereignty. But in investment treaties, we have to say that. We have to say that because of what you said earlier on. My dear friend from Pakistan, what you said earlier on, that investment tribunals have interpreted investment treaties as limiting the right to regulate of states. As limiting their right to regulate. And that's why today you have this counter-reaction in the context of the reform to say that, well, one way of balancing the function and objectives is to be explicit on the right to regulate. You see, I gave this example of the investment protocol of the AFCFTA, which I'm very proud of, on the right to regulate, where we put explicitly this provision to say, well, in accordance with customary international law and other general principles of international law, each state party has the right to regulate, meaning has the right to adopt measures, to achieve legitimate public policy objectives, even if those measures are going to affect foreign investment. And you see, in Africa, what we put in paragraph 3 of Article 24, we say, for avoidance of doubt, if you were still doubting, exercise of right to regulate doesn't give rise to any claim by an investor for compensation. If a state is in good faith exercising its right to regulate for the welfare of its people, no compensation under the African Investment Protocol. That's the balancing of the functions and objectives. Second level of the balancing the substance. Balancing the substance. I told you that, the dominant model of international investment agreements are asymmetrical. They are asymmetrical. I told you also that, there is imbalance and that the provisions are too broad. So balancing is not just balancing the objectives. It's about balancing the substance, the provisions on protection, on treatment. First, rationalizing the scope of investment standards. Making investment standards more limited in terms of scope. You cannot just say, the two contracting parties shall grant national treatment, meaning shall never discriminate between the local investors and the foreign ones. It doesn't make sense. In some context, you need to discriminate between your domestic investors and the foreign ones. You need to do so. If you want in a country to build national economic sovereignty, you need at some point to discriminate. So you cannot have no longer those provisions that just say national treatment, period. No, national treatment when the domestic investors and the foreign investors are in like circumstances. So that's what you find in new treaties. Again, I don't have time to show you, but if you look at the Japan-Angola treaty that I gave as an example, you will see that in the Japan treaties, they say, national treatment when the local investors and the foreign are in like circumstances. So meaning are in similar circumstances. If it happens that you are giving better treatment to your local investors that only have, three staff, you cannot give the same treatment to a foreign investor that has 1,000 staff because they are not in like circumstances. You should be able to discriminate. You should be able to say that this investor is protecting the environment, this other one doesn't do, so we should give better treatment to the investor that is protecting the environment, for instance, that is more climate friendly. Why not? You see? Then, defining the content of investment standards. That's another aspect of balancing the substance. That's another aspect of balancing the substance, defining the content of investment standards. Remember, one problem with the dominant model of IAs is that they led to very broad, expensive interpretations. Why? Because the investment standards in IAs are not clearly defined. They are not clearly defined. If you just say FET, fair and equitable treatment, period, then you allow whatever. You allow whatever. So if you want to limit, expensive interpretations, you need to go for a better definition of what is the content of those investment standards. So new generation of IAs go in that direction, where they would say, for instance, most favored nation treatment doesn't apply to procedural aspects. It only applies to substantive aspects, for instance. That's a way of defining. Or you would have some treaties saying fair and equitable treatment means A, B, C, D, E, F. So you can do that. Make the treaty more sophisticated. Then inserting exceptions. Inserting exceptions or what we call carve-outs in IAs. We are all lawyers here in the room, at least almost everyone. And in law, what we learn is that there's always principles and exceptions. Thank you. You go to the traditional dominant model of IAs, there's only principles. There's never any exception there. So one way of reforming, and many countries go in that direction, is now that they incorporate in the IAs exceptions to say, well, you know, yes, the principle is that you cannot discriminate, but exception, if you do it for health, if you do it for the climate, if you do it for the protection of human rights, etc., you should be able to derogate to certain of the principles. So you see, this is one way, for instance, to promote human rights. You put exceptions on human rights in investment treaties. Yes. If you don't put any exception, then you make it hard for a state to go in that direction. And then, last novelty that we find in practice, what we call investors' obligations. Investors' obligations. Remember what I told you earlier on? The traditional dominant model of IAs does not contain any obligation for investor. Only rights, 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 rights. Well, one way of balancing the substance, is now to incorporate obligations for investors. To incorporate obligations for investors. So, for instance, obligations not to engage in corruption. Yeah. Obligations to protect the environment. Obligations to respect human rights. You can do that. You can do that, you know. I don't have a lot of time, but one of the examples we will share with you is the Pan-African Investment Code. No? Yeah, thank you. See if I can show. One example I wanted to share with you, this is the 2016 Pan-African Investment Code, which is like a model, a continental model in Africa of 2016. If you look at the Pan-African Investment Code, what we did in 2016 was to incorporate, as you can see here, let me show you. It's here, sorry. We incorporate a chapter 4, as you can see on the screen, called Investors' Obligations. Investors' Obligations. Dealing with socio-political obligations, dealing with bribery, corporate social responsibility, natural resources, business ethic and human rights. So you see, it's possible to go in that direction. Then, of course, when you negotiate, you need to convince your partner, the partner country, to accept this, because not all partner countries agree with, you know, the need to incorporate investors' obligations. But in an era, I guess with the professor earlier on, you talk about the due diligence of, no? Due diligence of business companies. But due diligence has to be based on a minimum set of obligations. If you want to foster due diligence of businesses, you need to go in that direction of incorporating investors' obligations in eyes. So you see, the efforts have to be mutually supportive. Huh? So this is how you balance the substance with these four. And this brings me, and I'm almost done, on another aspect that is very important when it comes to the reforming. What we call systemic integration. Again here, many international lawyers here in the room are familiar with this idea of systemic integration. That a treaty should be a bridge with other fields of international law. You know, an investment treaties, dear colleagues, investment treaties, they cannot be clinically isolated from the rest of public international law. An investment treaty is part of international law. So what does it mean? It means that when we negotiate future generation of investment treaties, if we want to make them balanced, we need to make sure to integrate investment with other concerns or other fields of international law. So for instance, investment and labor. Nothing prevents to have in an investment treaty, I had actually an example in the Japan-Angola of a provision called investment, labor, human rights, and environment. All together. All together. Integrating them. You need to integrate investment and labor. You need to integrate investment and the environment. You need to integrate investment and climate change, etc., etc. So we can no longer be, in that generation of treaties that are so minimalistic, that just talk about how to treat, how to protect foreign investors. If you want investment treaties to be tools of sustainable development, to integrate sustainable development goals, then you need to have provisions on investment and. Investment and. That's the systemic integration. And this brings me to the last. This was the example of the Article 26 of the investment protocol of the AFCFTA on investment and climate change. We've been going in that direction to show that positive trends are going in that direction, so it's possible. But now I just want to finish with the last but not least level of the balancing. So we have seen balancing the objectives functions, balancing the substance, systemic integration, and number 4, balancing the procedure. Balancing the procedure. That's another aspect of the reform. If you reform investment agreements, but only from the substantive point of view, without reforming the procedure, then you nullify your efforts. The reform has to be, twofold. Huh? The reform has to be twofold. Reforming the substance, but also reforming the procedure. Because one of the problems, as we have discussed here, when it comes to the dominant model of IAs, one of the problems is not just the IAs, but it's also how they have been interpreted, how they have been applied by investment tribunals, for instance. So reforming cannot just be a substantive agenda. It has to be also a procedural agenda. And IAs can serve as a tool to reform the procedure. What do I mean by reforming the procedure? So, for instance, putting now more emphasis on dispute prevention. Dispute prevention is very important. Arbitration is very confrontational. I'm not saying that arbitration should not happen. I'm not saying that. I'm just saying that before thinking about arbitration, it's important to think about dispute prevention. Because at the end of the day, what do you want? You want to preserve the investment relation. Arbitration destroys the investment relation. Once an investor files a case against the state, it's over for that investor. It can't stay in the territory of that state. So one very good trend, very good recommendation is that IAs should focus now more on dispute prevention. How to avoid, grievances or differences to crystallize in disputes, to escalate to the level of dispute. So if you take, for instance, Brazil, most of the investment agreements of Brazil, they focus mostly only on dispute prevention. Brazil doesn't go for arbitration, for instance. You see? Then another aspect of balancing the procedure, if you can just give me 2 minutes, is to have more focus on alternative means of dispute resolution. Again, I'm not saying arbitration is not useful. I'm not saying that. But maybe arbitration should be at the end of the spectrum. What about using more friendly means, like mediation, conciliation? IAs can be tools where you can insist much more on that. And not just on the arbitration, which is, once again, very confrontational. Then, and I'm almost done, limiting the scope of the offer to arbitrate. If you go for arbitration in your treaty, in your investment agreement, the consent, the offer to arbitrate doesn't necessarily have to be a broad offer to arbitrate. That whatever can be submitted to an investment tribunal. You can say, well, When certain measures are in relation to health and so, maybe no. It is a matter of sovereign decision. Where I want to bring your attention is that you need, as developing countries, it's important that these IAs are tools for development. Not tools for limiting development, but for fostering development. And fostering development should allow a state to say, if I regulate in relation to the environment, you cannot bring me to arbitration. Sorry. So you can limit the scope. And we are seeing that today. And then, that's the last point, and I'm done. What we are seeing today more and more, and I saw it, for instance, in the BIT between Japan and Angola, a proceduralization of ISDS. Meaning, in the new generation of IAs, you now see detailed rules on how arbitration would happen if it happens. So you don't just leave it. You don't just leave it to arbitrators or to whoever to decide, but you use your IA to try to have more predictability on what can be done, whether the state can make counterclaims, for instance, on rules on independence, etc., etc. And today we are witnessing that. We are witnessing a new generation. You can look when you have time at home, the Japan-Angola BIT. You will see that you have many provisions regarding how arbitration would happen. How arbitration would happen. All that in the name of balancing investment treaties. Okay? So I will stop there. I know that I went few minutes beyond my time, but just one very last point, to make sure that my message is clear. My message is not to say that investment agreements are not good. I'm an international lawyer. I love treaties. I believe in treaties. Treaties are good. Treaties are good. And it's good that nations across the world, developed nations, it's good that they negotiate treaties. And it's good that they're continuing negotiating, concluding investment agreements or bilateral investment treaties. My message is to say the treaty becomes good when it really reflects your developmental needs, your developmental goals. The treaty becomes good when you have carefully thought about what you want to do with the treaty. So negotiating treaties for the sake of negotiating them is never really the right way to go. But if we get into that direction of negotiating a new generation of balanced international investment agreements, then international investment agreements will keep their promise, which is fostering investment, increasing investment, retaining investment, expanding investment for the welfare of the people of the United Nations. Thank you very much for your attention.
Thank you very much, Professor MBENGUE, for your very comprehensive lecture, and that gave us the overall picture of the development of the investment regime and also the challenges they are facing. So this concludes the sessions for today, and this afternoon we will be having the Asia Cup, a series of Asia Cup related events participated by Asian students. So we will be meeting tomorrow starting at 9 a.m. Thank you.